Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Somebody asks why it is so difficult to prove a fraud case when people have been defrauded. I'll have more on that in just a moment. Well, one of the reasons it's more difficult to prove a fraud case than almost any other case out there is because you have to prove the 9 badges of fraud. Now, the 9 badges of fraud sort of run together, but here they are in a nutshell. The plaintiff has to prove a representation, in other words, a statement, either writing or by implication, its falsity, its materiality, the speaker's knowledge of its falsity or ignorance of its truth, the speaker's intent that it should be acted upon, the plaintiff's ignorance of its falsity and his reliance on its truth, and his or her right to rely on the truth, and then their consequent and proximate injury and damages. So let's talk about a couple of things. Now, the representation, its truth or ignorance of its falsity, all of those things are pretty clear, but what about materiality? Well, it is possible to make a false statement that's not material. For example, you might very well say that a new car is the best thing since sliced bread. The term of art for that in the law is puffing and blowing, which I think is a hysterical term, frankly. It makes me laugh because I've seen salesmen, and I swear, they act like they are puffing and blowing. They're just blowing hot air. But it is possible to make a statement that is not material. In other words, no one has probably ever done a study to actually check to see whether or not that particular car is better than sliced bread. I'm a big guy. I kind of like sliced bread. So it'd be difficult for me to believe that a car would be better than sliced bread. But the point is, it's not material. It doesn't have the capacity to deceive or mislead you because you can't really take it seriously. The other couple of issues are the fact that when the statement is made, the person to whom it's made knows, or doesn't know rather, that the statement is false. If, for example, there is a big dent in the fender of a car that someone is selling, and you say, yeah, it's never been in a wreck, well, you can look right there and see that it has been in a wreck, so you don't have the right to rely on that statement. If nothing else, if someone says, well, a bike fell on it, then you can at least have enough information to go and check for yourself, get, for example, a Carfax report in that particular instance, and satisfy yourself that it hasn't been in a wreck. So that deals with the right to rely. In other words, if someone tells something that is within their personal knowledge and pretty much only their personal knowledge, then you probably have a right to rely on it. And since the advent of Carfax and other services that check out claims and can tell you what the history of a car is, you probably don't have the right to rely on somebody who says it was only driven by a little old lady who took it to church on Sundays. You have an obligation to sort of background things yourself. All of these make it very difficult to win a fraud lawsuit because you have this requirement to prove all of these things, and many of these things are defensible. Now, where it really gets to be an issue of fraud is where people have something that is within their personal knowledge that they know it isn't true. In one case I had where I actually defended the person who was charged with fraud. He had been accused of offering to sell 1,000 junk cars, but never actually intending to sell the 1,000 junk cars. He only wanted to sell a few so that he could clear out some room in his junkyard. And as a result, since he withheld that knowledge from the buyer, and the buyer didn't know what his actual intentions were, he was found liable for fraud in that case. And the Missouri Court of Appeals upheld that verdict. So again, it's a very difficult claim to make in civil court for fraud. It's almost as hard to make in criminal court for fraud. But there is, in some respect, a little bit of hope for people who have been defrauded in the commercial sense. For example, when you go into a business and a business tells you something that isn't true, or they use deception or other means, some kind of artifice, to keep you from learning the truth about what they're selling. Almost every state has what's called a little FTC Act. The FTC is the Federal Trade Commission, and there is a Federal Trade Commission Act that makes certain requirements for honest and fair dealing. And then states impose similar burdens. For example, Missouri has the Merchandising Practices Act, and it requires someone not to engage in essentially material misrepresentations that would lead someone to be deceived. Now, there have been some changes in that law recently to make it a little bit more difficult to sue under that statute, but the basis of the statute still remains, and it's a viable claim for consumers who are defrauded. But if you believe you've been defrauded, then you should go see an attorney immediately, tell him what happened, or tell her what happened, and find out from them whether or not you have a claim. This isn't something you should ever handle on your own, because there are multiple defenses and they're very difficult often to anticipate. So I hope you found that helpful or useful, and if you have any questions, please leave them in the comments down below. If you haven't already, please go over here and subscribe to our channel and tap on the notification bell so you can be notified whenever we release a video on this channel. Like, share, subscribe, you know all the stuff to do. And again, thank you for being here. Thank you for watching and paying attention to my channel. I'll catch you out here next time.